For delivery of orders, item number 1.
Mr. Jami, you are assisted by? Just write down that. We have considered the matter. We have dismissed the writ petition, but granted liberty to the petitioner to institute proceedings before the competent court of civil jurisdiction. Some corrections are there. You will have it by evening. This.
For delivery of orders, item number 46.
Don't give this, there are corrections. So just put it back in my table. We have maintained the position that you will retire as a senior divisional accountant, and the pension and other benefits would be accordingly calculated in the post of senior divisional accountant. DAO, we have not concurred because it was after the retirement. Sorry.
My pleasure, Lordship. I beg to mention hearing item 44 on behalf of the counsel for the petitioner.
44.
Lordship. Lordship, I was informed that the counsel for the petitioner is out of session since yesterday. So I pray that the matter will become after vacation.
You were appointed yesterday.
No, Lordship. The counsel for the petitioner is out of station since yesterday.
Who is appearing for the government here?
The concerned counsel is not present today, Your Lordship.
On the prayer of the learned counsel for the parties, a registry to list these matters again after the ensuing winter vacations. I was to allow this repetition today.
Lordship.
It's that compassionate appointment thing.
Lordship.
Covered by a division bench order. Okay, fine.
Lordship.
After vacations, maybe.
I also like to mention item 2, 3, and 4, Lordship. On the last occasion, I was directed to take instructions.
There is a disputed question of
Lordship.
fact. You withdraw it, file, go before the appropriate thing.
Yes, for that, Your Lordship. But then I haven't received complete information from the petitioner.
By
Your
2
Lordship.
p.m. By 2 p.m. We are not taking this matter forward.
Lordship.
2 p.m. we'll call it again.
Lordship.
May I please, Your Lordship?
2, 3, 4 at 2 p.m.
May I please, Your Lordship? Lordship, I beg to mention item 28. And the state is yet to receive instructions. So we pray for some more time, Your Lordship. 3 weeks, Your Lordship.
This person is a compassionate appointee. Why
Yes.
keep this matter pending? You consider
I've
in
not-
terms of
Yes.
in terms of your
Waiting list.
in terms of your policy. Consider his case. He's waiting for now 3 years now.
Lordship.
Why? Do it. We'll dispose it of today. Right? Be here when the matter is called up.
May I please, Your Lordship? Your Lordship, in item number 14.
1-4.
Yes, I have an instruction to appear on behalf of respondent number 9. So kindly list the matter after the vacation so that to file my local number as well as for my reply, Lordship.
You are appearing for the
Respondent number 9.
and who is for the petitioner?
Lordship, I've taken the concern of the petition, Lord.
Okay. On the prayer of the learned counsel for the respondent, registry to list this matter again after 2 weeks on a date to be fixed by. Stop. The said prayer is stated in the bar to be made with the consent of the learned counsel for the petitioner. Full stop.
Much obliged.
May I please, Your Lordship? I beg to mention item number 6. Yeah, I've just filed my reply this morning, so if it can be listed after the vacation.
The learned counsel for the petitioner submits that the affidavit in reply on behalf of the petitioner has been filed today. Full stop. You're for the respondent?
Lordship, I'm for respondent
You've got a copy?
Lordship, please.
Post she further praised that the matter be taken up after the ensuing winter vacations. Prayer is not objected to by the learned council for the respondents. Post registry accordingly to list this matter again after the ensuing vacations on a date to be fixed by.
Lordship, in hearing item 45. Here, the hearing is completed and parties were given liberty to submit their written argument. So we have submitted our written argument
On
online.
behalf of the petitioner,
Yes, yes. No, no, on behalf of the respondent.
respondent.
Yes. So I may be allowed to submit the citations in the course of the day.
We'll reach, when we reach there, you complete your things. By the time we reach there, you complete it. I'll reserve the order. Yes. Yes, madam. You're for the same item, item
Yes,
number
Your
4.
Lordship, I'm for the petitioner in this case, Your Lordship.
Okay. You have to submit any written arguments or something? No.
No, Lordship, just
Fine, fine, fine. You complete that whatever is there, then we'll take care of it. Yes, Mr.
Yes, your Lordship, I would like to mention item number 42. Your Lordship, the petitioner counsel given to his native village to attend one funeral service today. So kindly,
The
one.
prayer
request.
is made on behalf of the learned counsel for the petition
Yes, your Lordship.
for an adjournment in the matter on the ground that he is in bereavement. Prayer accepted. No issue, no issue. Prayer is not objected to by the learned counsel for the respondents. Registry accordingly to list this matter after the ensuing vacations, winter vacations on a date to be fixed by 42.
Yes. Obliged, Lordship.
Lordship, I will allow to make a mention for submission item 13.
Item
Item 13.
13.
13, yes, I have received the counter affidavit filed by the private respondents, Lordship. The affidavit in reply is under drafting, Lordship.
What reply is required? Your body consists of around 18 persons, or sorry, 22.
Yes, Lordship.
18 have already resigned. Otherwise also the body is gone. So what is the now big thing? And the allegations,
No, Lordship. Lordship,
they have not resigned.
this is stigmatic, Lordship. That is the issue. And Lordship,
And okay, what is the particulars of the?
just because
Mr.
the-
Counsel, what is the particulars of the Supreme Court case?
I have annexed, Lordship.
Where? Okay, let the matter come up, we'll see.
May I please, Your Lordship? Lordship, I beg to mention item number 5 of today's conference.
Item number?
5. The arguing counsel in this case is from Gauhati and is indisposed and under medication. Lordship, may we kindly please to allow adjourn the matter for today.
It is submitted that the arguing counsel is indisposed and accordingly not in a position to appear in the matter today. A prayer accordingly is made for adjournment in the, for adjournment. Full stop. Prayer is not objected to by the learned counsel.
Respondent number 5, my lord.
Response. Full stop. Accordingly, registry to list this matter again after the ensuing winter vacations.
Yes.
You could have told me yesterday. Okay, fine.
Much, Lordship.
May I please, my lord, item number 30 to 34. This was listed on my prayer. However, Lordship, upon reaching the court, I got a call and I have some personal urgency for which I need to go down to Dimapur.
Mr. So-and-so learned counsel for the,
Kindly accommodate for a day.
Mr. So-and-so learned,
I Jamil.
I submit learned counsel for the petitioner. In the above noted writ petition, submit that he, on account of a personal inconvenience, would be required to leave the court immediately. So accordingly, he prays that the matters be taken up after a week. Full stop. Prayer is not objected to by the learned government advocate appearing in the matter for the respondents. Also, registry to list those matters after a week on a date to be fixed by. Registry shall also furnish a status report with regard to the service of notice upon the private respondents in the above noted writ petitions.
I love that.
Yes, Your Lordship. I may be allowed to mention item 17, Your Lordship. Here the state is yet to file counter.
Item number
17. So I may kindly be allowed some time to file counter, Your Lordship.
Madam, this order is not, it's too, no counter is required. High Court directed you to consider regularization of that period. Now you have gone up and said that it is dice non,
Your Lordship.
too much.
No, this is with regard to back wages, Your Lordship.
Imagine that. You said that that period dice non, do you know the concept of dice non? Dice non means the earlier service is gone. Only the remaining service, whatever he has, it will. How can you pass? The court literally has given her complete relief, but there was no prayer. That is why the matter was remanded to you. Go through it. We'll try if we can. We'll. That order has to go. We can't pass a mandamus. You reconsider. That's all. You reconsider. Because the earlier order has not passed a mandamus. I can't pass a mandamus. We will only interfere it saying that it is not in terms of the directions passed by this court. So a review has to be made. Do it. That's all. Will not trouble you much.
But since Your Lordship, since I had already received instruction, I may be allowed.
What is your
to-
instruction? What is your instruction? You place that. That'll do. Yes.
For admission, item numbers 7 to 11.
There are two aspects.
Yes, my lord.
One is the parity of pay and the other one is regularization.
Yes,
Which one would you like to address first, regularization or parity of pay?
My lord, I'd like to address first the parity of pay.
Okay.
Yes. Your lordship may kindly see my affidavit, my lord. Affidavit in opposition, my lord.
Page.
Para 6. Kindly allow me to read para 6.
Affidavit filed on 3/9. Affidavit filed on 3/9.
30, 38.
How many affidavits? Only one affidavit?
Yes, only one.
Okay. You are taking up item number 214.
Yes. the
Affidavit
first
in
one.
214. Yes. Yes. Para.
214, yes. Para
Para.
6, para 6.
Okay, para 6.
Kindly allow me to read, my lord. That with regard to the statement made in para 7, 13, 15, and 17 of the writ petition, the answering deponents beg to state that in response to the assertions made in para 7 of the writ petition, as the name indicates, the term of temporary ordinary grade waters appointed for a term of 1 year and regular waters are different, and consequently they enjoy different pay structure and service condition. There is no provision to grant parity. The answering deponent beg to state that the nature of post of the temporary ordinary water by itself temporarily, whereas the nature of appointment, educational qualification of the regular wardeners are regulated by the rules. Besides, it is relevant to state that the government of Nagaland has not taken any policy decision to accommodate those temporarily ordinary grade waters as regular water for the jail. The answering deponent further begs to state that the claim of the petitioner is misconceived. in as much as the questions of unequal treatment does not arise in the instant case for the reason that the principle of equal pay for equal work cannot be claimed solely on the basis of similarly situated warders in the same jail under the same department. It was well settled that the doctrines of equal pay for equal work could only be invoked when the employees were similarly circumstances in every way. The mere similarity of designations or similarity of or condom of work as not determinative of equality in the matter of pay scale. It may be pertinent to point it out that the petitioners were appointed on exigency and their appointment can never be equated with the regular wardens.
Okay.
And as such, in the instant case, the unequal or different treatment cannot be treated as arbitrary in terms of the different footings of their appointment. So, my lord, their case is petitioner service is governed by Nagaland Jail Rules, Service Rule 2010.
They are not governed by the rules of
No, my lord.
2010. They are not governed. They are outside the provision of that rules.
No, my lord, that pay that the person ROB.
The regular warders
Yes,
are covered by the Nagaland Jail Rules 2010.
yes.
No issue.
And the same pay scale they are given, the pay scale has been given under this rule, my lord. They are getting the same scale of pay, my lord. Your lordship may kindly see the annexure. Your lordship may kindly see the annexure.
Where?
Page number 19.
Yes. Warder.
Yes, water 11, serial number 11. This is the scale they are enjoying now, my lord.
Presently.
Yes.
2,750, 4,400 or the revision of.
Yes, my lord.
Have they been given the revision of this pay scale?
Yes, they are receiving this. They are enjoying it.
Today they are getting.
Yes, my lord.
The same pay scale as a warder.
Yes, my lord. Because the appointment is clearly says that the scale has been mentioned, my lord. In the appointment, it's clearly mentioned the scale, my lord.
No, I got it.
Yeah.
This is a scale of 1992-93. Your rules came in 2010. This is a rule. This is a scale prior to the fifth CPC. Now tell me whether the persons are getting the scale of pay a regular warder is also drawing.
No, man. Now the regular warden, they are regular warder, they are drawing the 2017 ROB, my lord.
Why?
Because they are regular.
Okay.
They are regular employees.
Regular employees.
And my lord,
Then if you say that the person appointed with this scale of pay, which is mentioned in the rules, will not be given the latest ROP, while the regular appointed under that thing, his pay has, they are only to be given the minimum of the pay scale. That's
yeah,
all.
this is the minimum pay, my lord.
2,000, where is the appointment order? Okay. Anything more?
Yes, firstly, my lord. So, my lord, my first ground is, my lord, in regard to parity of pay, my lord. Since they are enjoying this minimum scale of pay as per 2019 ROB, they are not entitled ROB 2017 because ROB 2017 is only meant for the regular employee. You kindly see the ROB.
Mr. Counsel, they are not asking for the scale of pay. They are asking for the minimum of the scale of pay. That's all. We don't want ROP. We have enough papers.
No, my lord, in the prayer, they are asking for ROB 2017.
That let them ask the sun.
Yes.
They'll always ask for the sun. At least they get the earth. They want the earth. But if you ask for earth, you will give them hell. The concept, na? Hell is
Yes.
down, earth. So they ask for heaven. So at least let them get the earth. Human subsistence.
So, my lord,
You are agreeable to give them the minimum of the pay scale.
already enjoying, my lord.
No.
They're already
ROP,
enjoying.
ROP, latest.
ROB 1999, they're
No,
enjoying.
ROP 2017
And
minimum.
my lord, in the case
Are you
of
agreeable? We'll not trouble ourselves with the judgment. We'll record that and give it.
my lord, in this regard,
Regularization, I leave it to you.
yes, my lord, in this regard, I want to rely on one judgment, my lord.
Yes, please. Judgment of this bench or Supreme Court? What is that? Party?
State of Punjab versus
Okay, Jagjit Singh,
Jagdish Singh,
para 60.
para 60 and 61. My lord, here it says that if the temporary employees are performing the same duties, they're entitled for minimum scale of pay below the lowest grade of the regular pay.
Right.
So they are enjoying, my lord. That is
That's
the
your
commission.
understanding.
Yes, that is must.
Unfortunately, that is not Tikku's understanding. Anyway,
And in regard to second ground, my lord,
Hmm.
regularization of service.
So this is done. This is what you want for.
Yes, my lord. They are not entitled under 2017 ROB, and the minimum scale is already enjoying.
Regularization, what do you say?
In the regularization, my lord, I want to rely on one judgment that is State of Karnataka versus Umadevi, my lord.
Okay. Anything more?
Para 44, 45, 46, and 47, my lord.
Yes. Anything more?
That's all, my lord.
Yes, any reply?
My lord, kindly allow me to submit my written.
Good. Yes.
First, my lord, with regard to the pay parity, we are also asking for only the minimum base scale. And with regard to regularization, Lordship, I have extensively submitted. And then, Lordship, just to substantiate and reply to my friend, I just want to supplement one letters. Cite one judgment, Lordship.
Yes.
2025 SEC online SC 837. Devela Chakan, my lord will be aware of this case. Lord, here the bit.
Puducherry.
Yes. Here, they were in the absence of service rule, they were appointed on hourly basis, but
Anything more?
substantially, yes. That is my submission, Lordship.
We'll consider that.
Yes, Lordship.
Just put it for tomorrow. If I can dictate it, I'll dictate it today. We'll deliver it tomorrow. Just put it for hearing only tomorrow. If not, then tomorrow I'll reserve it.
My lord, just to assist this court, I've made a chart with regard to all the 5
That will be very, very helpful. The judgments that are made, keep it up for tomorrow.
Yes,
If possible, if I can dictate, I'll dictate it today. Let me see if I can dictate it today, I'll dictate the orders today.
Much
Much
obliged.
obliged, Lordship.
Just give it to me in my chambers. Huh? Just give it to me in my chambers.
For admission, item number 12.
Call it after some time. Oh, you're there. 12.
Yes, my lord.
Oh, yes.
Lordship, unlike in the other case, Lordship, unlike in other cases which my Lord has cited the other day, Lordship, here the school is being actively managed by the government, Lordship.
Show me something.
Lordship, Annexure 4.
Now you come to your
Page
appointment,
21,
you come
my
to
lord.
your appointment order.
My appointment order, my Lord.
Hmm.
Annexure 1, yes.
See the condition at serial number 1 there.
Yes, Lordship. So, Lordship, they may have a fund, Lordship,
No,
for that,
that
Lordship.
if this school, you are here as a private teacher, you're not here as a government teacher. And the rules that you are referring to is for the private teachers in the school.
No, my Lordship. Here, despite that, Lordship, the school is being managed by the state officials, Lordship, and Lordship.
Yes, Mr.
My lord.
Advocate,
Yes.
what is the status of the school?
Lordship,
The
actually,
toleration is also being granted, Lordship, here.
the name of the school is Second NAB School. The nomenclature is such, but it is a purely private school. It
Who
is,
manages it?
it is managed by the management committee. Management committee of the,
Management committee
School.
consists of whom, Lordship? That is the important question.
the managing committee also, it is headed by the commandant. But even if the other side is a commandant, but school is purely private.
There is no money given by the government.
No,
for
no,
management.
no, no.
No statutory.
There's no,
All the employees are,
yes, by the management.
now why are there are two categories of employees, one private, one government, like that, something, nothing.
No, no, no. This is purely only the nomenclature and the officials of the managing committee are officers because it is in the camp. It's a second and a battalion camp. So managing committee, most of them
You
are
have not
police.
filed an affidavit here.
Yet I already done.
You've got your instructions.
I got the instruction.
Okay. On the prayer of the learned council for the parties, registry to list this matter again after the ensuing vacations, winter vacations. The respondent shall ensure that before the next date of listing, the affidavit, the affidavit on their behalf shall be brought on record. Full stop. It is to be noted that the learned additional advocate general, government of Nagaland, Sarkar Nambi Lilichega, write down his name, has raised a issue with regard to maintainability of the said writ petition. So the said issue would be considered upon the affidavit being filed by the respondent, bringing on record the status of the school in question. Mr. Counsel,
My Lord.
for your benefit,
My Lord.
that is what has
My
restrained
Lord,
me
my Lord,
today.
my Lord.
2025 SSC Online SC 1192.
My Lord, my Lord.
There is a dissenting opinion
My Lord.
of Justice Amanullah.
My Lord.
Read that.
My Lord, my Lord. My Lord.
That
it
will
highly-
give you an idea to,
Is it against the St. Mary's School?
aha, he has gone a step further. With regard to that school, somehow it here. So I said I should wait in this one. Otherwise, that day I was totally against him.
My Lord.
While reading, I got this. Today's dissent is tomorrow's law, they say.
My Lord.
But go, you get a line to argue.
Lordship.
Try that. 2025 SSC Online SC 1192.
My Lord.
Dilip Kumar Pandey.
My Lord.
There was some Air Force school thing.
Lordship.
And if you can bring that concept into this,
Lordship.
so maybe without going into that, we can help you.
My Lord.
Fine.
Deeply obliged, my Lord.
For admission, item number 13.
Lordship was asking me about the Supreme Court order, Lordship. It is at Annexure 4, page 26, Lordship. When the client initially came to me, he was narrating the facts to me. I told him if I am
Page
26, Lordship. He did not have a copy of this with him, Lordship. So I told him
of the writ petition.
no, of the Supreme Court's order, Lordship.
Now, where do I get the Supreme Court?
Page 26, Annexure 4 from the
Of the writ petition?
Yes, my lord. So I told him from the case status and from, because these days we can obtain Supreme Court's order from the case status detachment information.
Page
system.
26, huh?
Yes, my lord. So if I'm able to obtain it, I'll represent you for the High Court. And if I'm unable to get it, I cannot file a case on your behalf, Lordship. So, my lord, the petitioner, Lordship, he hardly knows how to write his name. He is from perhaps one of the most backward areas in Nagaland, Lordship. So for.
No, I'm not on this.
Yes, Lordship.
Not
Now-
on this. When was the action taken against you? By the complaint was lodged sometime in May
Yes, Lordship,
2017. And the complaint is
The
that,
Bune order was passed on 24th of February this year, Lordship.
no. The complaint that was raised.
On 31st of August 2024, Lordship. These are all, Lordship, politically motivated, Lordship. Otherwise, Lordship.
Now
when
the
case was
issue, now,
filed-
Mr. Council, the problem here,
When the case was filed before
the
the Supreme
village
Court.
council has some meaning,
Yes, Lordship.
has some meaning in the conduct of the proceedings of the society. It has a importance.
Yes, Lordship, Lordship.
Now, you don't have a village council.
We do have, Lordship,
Where?
Lordship,
The 18 persons have already resigned.
Lordship.
Then,
Lord,
what is the position now?
No, your lordship, the village council is dissolved,
Dissolved.
On account of, my lord has rightly pointed out, on account of those 18% resigning, on moral ground, your lordship, on
Be
moral.
that as it may, now, there is no village council now,
No,
because
there's no,
the stay is there.
yes, there's a stay.
Okay,
Lordship, if it can be taken up tomorrow, then, Lordship, this matter.
Today. Why?
Or at 2, Lordship.
why?
I would like to go through the facts, Lordship.
Facts is very clear.
Lordship.
The 18 persons, they have
Due to
filed an
paucity of time, I
affidavit.
was unable to go through the affidavit filed by the respondents, Lordship.
That was filed long back,
No, Lordship,
3/11.
yes, 311, Lordship. Yes.
Today we are 24.
Yes, my lord.
26, 27, 24 days.
Yes, my lord. At 2 today, Lordship, if it's not a big problem.
But I'll not permit the non-functioning of the council. If you have to have your stigma removed, have it removed, we have nothing to do.
Lordship,
But the
Lordship,
stay that is operating today, I'm vacating it.
Lordship.
For admission, item number 15.
Yes. Which is the period you have not got your salary?
Lordship. There is a dispute, Lordship, because there was backlog in the payment of salary.
Now the stand of the authorities is
Yes,
that they have not released you salary from April 2020 to October 2022.
yes, Lordship.
And they have given an undertaking in the affidavit that they will release it by 31st of August
But it
2020.
has not been
Have you-
released yet.
Yes, why have you not released that amount?
You know, your lordship, we're ready to release the pending
Huh?
salaries.
Huh?
We're ready, your lordship.
Release it.
Yes, lordship.
You have undertaken that you will release it in 31st of August.
Yes,
And
lord.
beyond that, I don't think you have any.
Yes,
claim.
Lordship. And Lordship, if they release that pending amount.
We'll ask them to do it in within
Yes, my
15
lord.
days.
My lord, my
We are
lord,
closing this.
my lord, my lord.
Heard Mr. So-and-so, on a council for the parties. The present petition was instituted by the petitioner praying for release of her due salaries from which has been stated to be in areas with effect from April 2020 till the date of filing of the writ petition. The petition respondents had entered appearance in the matter and filed a affidavit. In the affidavit, it was clearly stated that the salaries of the petitioner were being regularly paid till the date of her termination from services. However, the salaries of the petitioner with effect from April 2020 to October 2022 was not released. Full stop. The respondents have claimed that an amount of rupees 5,58,741 is receivable by the petitioner, being the area salaries for the period April 2020 to October 2022. Full stop. You agree to this?
My lord, my lord.
The learned counsel for the petitioner on instructions has submitted that the petitioner is to receive her area salaries for the period April 2020 to October 2022 and accordingly accepts the contention of the respondents made in this connection. Full stop. In the affidavit, the respondents had undertaken to clear the amount, the areas of salaries of the petitioner for the period April 2020 to October 2022 on or before 30/8/2025. However, the learned counsel for the parties have submitted that the said amount has not been released by the respondent university and the respondent university. Full stop. The learned counsel for the respondent university submits that the amount involved would be released within a period of 15 days.
Lordship, if your lordship may be gracious enough to grant us 2 months' time.
Not, it's within 7 days from today. Failing which, the amount will carry interest at the rate of 8%, 6% from the date the amounts involved were due till the date of its release. With the above observations and directions, the present writ petition stands disposed of. You said 31st August in your affidavit
Yes,
on
your
oath.
lordship, in my reply, I have clearly stated that if the petitioner has agreed to my agreement, then we're ready to release.
She has
Until
agreed.
then-
You in paragraph 17, you have said, just put it, madam, put it 15 days and that interest part deleted.
Deeply obliged, my lord.
15 days pay her.
For admission, item number 16.
Oh, just add one line there. As agreed to by the learned counsel for the parties, the present writ petition is taken for final consideration and disposal at the admission stage itself. Yes,
Yes, Your Lordship.
yes.
As per the last order, Your Lordship, I was supposed to bring some instruction with regard to the process of the petitioner's case, Your Lordship. Here, with regard to two petitioners, Your Lordship, the OIM clearance has already been given. And then the matter has been forwarded to the government. Now the government will forward the same to the PNR department. After that, it will.
What about the other two?
Other two, the petitioners had submitted their affidavit yesterday. So they'll be forwarding the letter to the government and the government will forward the same to the PNR department.
So any problem you are facing now? The petitioners are facing any problem?
No, no.
Madam has taken care of everything.
Yes, lord.
Okay. Ms. So-and-so, learned counsel representing the respondent submits that the case of the petitioners for inclusion of their names in the PIMS,
Yeah, it's not inclusion for correction. yeah.
correction of their
Correct.
particulars in the particulars
Yes, Your Lordship.
in the PIMS is currently being processed and the same would be taken to its logical conclusion within a period of
Your Lordship, 3 months, Your Lordship.
3 months from today. So, accordingly, she prays that the matter be taken up after 3 months, enabling her to apprise this court about the developments taking place. So, the learned counsel for the petitioner.
However, 3 months, that's too long.
Your Lordship,
It takes comment. Say now 1 month, though, it's a holiday.
21.
No, it's holidays. It's Christmas, New Year. We don't work, then how do you expect the government to work here? So Festive season, everybody should enjoy. Then prayer is not objected to by the Learning Council for the petitioner. The registry to list this matter after 3 months from date to day on a date to be fixed by. If doesn't come, make a mention. We are here.
Much obliged.
For admission, item number 17.
Madam, come to the directions passed by this court. Come to page para 23.
Yes, Your Lordship.
See the last line. It can be safely concluded that the petitioner is entitled. A conclusion is recorded by this court. Then it says that, okay, there is no prayer, I'm remanding back to you. Now you come to your order. As known, everything wiped out. Not even notional fix. If you had done notional fixation, maybe I would have kept my hands away. Done nothing. So clear violation. It's a case of contempt, actually. Maybe they have not understood the implication. There is a conclusion, ma'am. That much, if you don't value a court's order, it doesn't reflect well. Who is this authority? Home Commission. He should have dealt with this matter in a more refined manner. Kindly inform them. We are setting aside this order. Right? Please don't feel any apprehension. What do you have to say? Tell me.
Your Lordship, okay, my submission may be recorded that I was.
Okay, you file
inclined
your
to file
affidavit. You file your affidavit. The Learned Counsel for the respondent submits that she would file the affidavit in the matter on behalf of the respondents represented by her on or before.
Your Lordship, 2 weeks.
Date.
Date. Seventh, Your Lordship.
11?
Yes, Your Lordship.
11/12/2025. The authority issuing the order dated. Now I'll have to bring that thing in there. Order dated 19/5/2025 shall highlight in the affidavit the manner in which the consideration of the issue with regard to payment of back wages to the petitioner herein was considered. Full stop. The authority shall also highlight as to why the prescriptions, the conclusions drawn by this court in para 23 of the judgment and order dated 8/4/2024 in WPC number 356/2021 was not considered while proceeding to hold that the period of service rendered by the petitioner, other than the period of absence of the petitioner with effect from 12/5/2016 to 15/5/2025 shall be treated as a dies non. It is provided that there being a categorical conclusion reached by this court with regard to the entitlement of the petitioner to her back wages, the authorities could not have taken a stand contrary to the said position, the said aspect of the matter, and as to whether a contempt proceeding would be required, sumoto contempt proceeding would be required to be drawn up in the matter against the authority passing the order would be considered on the next date of listing upon filing of the affidavit in question. Now I can't help it. You have forced me to do that.
For admission, item number 18.
Maybe it's Lordship. Lordship, starting from item 18 to till 20 something, it's all are similar matter.
All during the pendency, you have been terminated. Challenge that termination order.
Lordship, if the Lordship allow me to make a submission, a short submission on this line. Lordship, my petition, my approach of petition is,
That last line with regard to contempt, just cut that. The rest will remain.
Lordship, my approach before this honorable court is asking for my backlog salary. And ask the second.
No, the problem, Mr. Counsel, here is
Lordship,
you are found to be a non-entity. So if you are found to be a wrong entrant, you're not found to be anything, why the salary? You'll have to challenge the termination.
Exactly, I'll come to that, Lordship. I'll come to that. So why I'm saying is that, see, why they have issued me termination order? Meaning, I'm existing in the department.
That existence is no existence.
Lordship, now, Lordship, I have claimed for 52 months. Now they have issued me termination on the 6th November. So if say so, why they should deny me the salary for that prior to that termination order? And Lordship, I would like to have a humble submission before this honorable court is that this termination order was never served to me. After the institution of this present writ petition only, they have brought to the record, and then only we came to know. The petitioner came to know about this termination order. So I will take instruction. I'll take instruction from a petitioner to challenge this in the other writ petition, Lordship.
Yes,
but Lordship,
we will permit you to pray for your salaries also, because see, Mr. Counsel, the problem is this.
Lordship,
once you have been said to be a bogus appointee without following any procedure,
Lordship.
Please, pardon me. There are decisions of the Supreme Court which says that you're not entitled to trial.
Lordship, I agree with that. Now, Lordship, what happened in this Nagaland is that we have thousands of work charge employees in every department. Now, in order to authenticate those employees, Lordship, they have instituted this district verification committee. And then accordingly, the district verification committee has verified our.
What do you want?
Lordship, what I'm trying to say is that if in my humble submission, if this termination order, I'll go for that, challenging that in a different.
You cannot make, that's why I told the person who was appearing the other day.
Lordship.
Amend this writ petition or file a writ petition. I'll give you liberty with regard to salary also.
Lordship, in that case, Lordship.
I'm giving you liberty. I'm not.
Lordship.
I'm only wanting that without that order. See, now that order says that you are an illegal appointee.
Lordship.
My hands are tied. I cannot give you a direction for payment of salaries. Once that order goes, it's open again for me to pass.
Lordship, they have issued my short submission. They have issued termination order, and then see, they have never stated that we are not existent in the department.
But illegal existence is also no existence.
And then they have paid me salary for till 2021. And then termination order was issued only after 2 years, 3 years, that is 24.
Item number 18 to 20?
27.
No.
26.
26.
Yes.
18 to 26. The petitioner, the petitioners in the above noted writ petition had approached this court praying for a direction upon the respondent authorities to grant them scale of pay in terms of the provisions of the OM dated 17/3/25. This is the prayer in all the writ petitions. Prayer is same in all.
Yes, Lordship.
17/3/2015. Full stop. With effect from 1/4/2025. Full stop. During the pendency of the present proceedings, the respondents have entered their appearance in the matters and have filed affidavits. Full stop. In the affidavit, it has been brought on record that on a scrutiny of the particulars of service rendered by the petitioners herein, petitioners in the above noted writ petitions, it was found that they were placed in the doubtful category. Accordingly, on a processing being made in the matter, which also involved issuance of show cause notice, comma, disputed by the petitioner herein, comma, the petitioners, services of the petitioners came to be terminated by issuance of notifications, all dated 6/11.
Yes.
All dated 6/11/2024. Full stop. The services of the petitioners now having been terminated, comma, the petitioners are required to challenge the termination order so issued in their respective cases. Full stop. The Learned Counsel for the petitioner, in view of the developments taking place in the matter, has submitted that he be permitted to withdraw the present writ petition with liberty to challenge the termination of services of the petitioners in the above noted writ petitions. Full stop. The prayer is not objected to by the Learned Counsel for the respondents. Full stop. In view of the above, the present writ petitions stand dismissed on withdrawal with liberty to the petitioners to assail their respective termination orders and as well as to reiterate the prayers made in the above noted writ petitions.
Let's.
Now come back fully armed, we are here.
For admission, item number 27.
When are you retiring?
My lord, hardly 4 to 5 years has lived.
4 to 5 years. I think we'll have to keep this matter pending for another 2 years. What is this conduct of yours? You were suspended in 2016. You sitting very,
No, my lord.
very without any problem. Why?
Yes, that
Murder case.
it's a murder case.
Pleadings are complete.
Yes, my lord.
Pleadings are complete, ma'am. You have filed your affidavit. As prayed for by the Learned Counsel for the parties, the matter stands admitted for hearing. Had the Learned Counsel for the parties, full stop. Admit the writ petition for hearing. Registry to list this matter for hearing after the ensuing winter vacations on a date to be fixed by.
Much better.
For admission, item number 28.
Who is appearing for the respondents? 28. Madam, you are appearing 28? No. I have deleted the contempt part. I don't want to put you in trouble. I've deleted.
Bless your lordship.
But the other thing you'll have to explain.
Yes, your lordship, I'll do my, whatever I can.
Lordship, I had just received that waiting list from the department. Hence, I went to make a Xerox copy of that.
What is his name is there?
Yes, it's like 249.
249. Oh, will that come?
I'm sorry, I could not put the pages.
No need. Mr. Counsel, you are producing this under authority, so don't worry about that.
It's on the 7th page.
249.
Yes, 7th leaf.
Ongma Pom.
Yes, your lordship.
So, Mr. Counsel, so these people are eligible
Yes, this is as per the.
after scrutiny.
No, as on the receipt of applications.
Huh.
And
Now, how will their cases from here be considered?
when their turn comes,
Hmm.
they'll be scrutinized that time. As and when in turn.
I didn't get it. How do you prepare this list? Anybody supplying an application,
Yes.
you put him in this list. Is
Yes,
that the way?
Yes, your lordship, but as per first death basis.
Okay, fine.
Yes.
You don't make a scrutiny before this whether he is eligible or not.
Usually no, your lordship.
Where do I get the, any additional advocate general present? Mr. Simpson, just give him a list. Give that list to him. Now, if you come here, he says that this is the list now pending for consideration.
Right.
Now, the problem, see what is happening. They see serial number 1. Serial number 1. Right? The person, the government servant expired on 31/1/2003. Right?
Yes.
Now, after 22 years, what is the compassion? But the persons who have recently gone, they will require 22 years he has survived. I think you got to relook on your scheme. There is a decision, Devobroto, State of West Bengal versus Devobroto Tiwari. Kindly go through that and advise your government. Because if you maintain this, this never will happen. And this is not the concept of compassionate appointment. Cannot be. Compassionate appointment is immediate.
Yes.
Because otherwise you'll be running yourself into trouble.
Yes.
I'm not doing anything in this case. You please have a relook into this. On the prayer of the Learned Council for the respondents, registry to list this matter again after the ensuing winter vacations. It is to be noted that the Learned Government Advocate had produced a list of applicants for appointment on compassionate ground pending consideration. A perusal of the said list reflects that therein names of applicants whose names of applicant figure wherein the death of the government servant had taken place in the year 2003, 2005, 2006. So, after lapse of considerable period of time, the Learned Government Advocate shall also receive instructions as to what the government proposes to do in the matter so as to ensure that the actual intent and purport of an appointment and on compassionate ground is achieved. I'm only saying that much. Just look into it.
Advice, Your Lordship.
For admission, item number 29.
This matter is listed for consideration on the interim relief, my lord. Last hearing, my lord, respondent number 1 did not appear, so it was not considered. But this is a case of a declaration of a non-purpose.
Yes. You are
Yes,
appearing
Lordship,
for?
I'm appearing for respondent number 1.
What is your stand?
Lordship, if we go to the first annexure, there is annexure P1 of the writ petition. It starts from page 103 of the writ petition. We have given them sufficient show cause notice. And thereafter only we have made the decision to.
Where is the show cause notice?
Or may I bring some certain facts, my lord?
No, where is the show cause notice? This is the.
Lordship,
This is the show cause notice. Why it is not sufficient, Mr. Right? Raj?
Or kindly come to annexure P10, lord.
Huh?
Annexure P10 so called notice, my lord. Lord, petitioner is a silent partner of the JV firm, the contract was executed by the lead firm, my lord.
You file your affidavit. I'm sorry. If it is a JB, both are involved. The partner gets a notice.
Please see for so called
Page.
page 177, 177.
Now, in the same thing, can we take a different?
I have other grounds for.
That we'll argue when the matter is taken up. Now, the question is whether notice.
Please see page 10, lord. Page 177, lord. Dated 3rd of May 2024 is the so-called notice. Only through email. And please see the email ID, my lord. This email ID is of the lead partner, my lord. Neither so-called notice.
Show me the condition in the contract that any communication has to be issued to both the parties.
Yes, my lord. Kindly, my lord, For a moment, come to page number 127, Lord. This is JV letter which was given to the respondent, Lord. Number 1, dated 6th of May 2023. It is given to the respondent, Lord, Mr. A.K. Jha. Please come to para 1, my lord. We AI Bond, which is the
Come to 2, you recognize Armagne Engineering Private Limited to be the lead firm
Yes,
and responsible to the client for the progress and success of the project. Now show me from the contract agreement that any such notice has to be given.
No, when the punishment order is passed, my lord, it has to be served upon him, my lord. There is a violation of
Your
natural
name,
justice, my lord.
let them file their affidavit. You file the affidavit by Wednesday.
This order is against the circular which they are relying, Lord.
Okay, that is 1 year, minimum 1 year.
6 months, Lord. As per their allegation, 6 months maximum.
Okay, 1 year. You say it's, you
6
say,
months, Lord. Can you see the circular?
when was this order issued?
11.
6 months is still time. Still time for 6 months at least.
I'm saying that any punishment order which is passed beyond the provision of law.
Sorry. You file your affidavit by next week.
Lord, may I
Lordship.
Every day I am suffering, my lord. I have already lost, my lord, 3 contracts.
Can't help it.
Lord,
I'm not passing
give me
any.
at least 2 weeks.
No.
Lord, may I rely on one order, my lord, recently passed, my lord, by Supreme High Court. Identical case against the same respondent, same.
If you want, I'll reject your writ petition. You can go upon appeal.
Lord, please come to page. Second page, my lord.
I'm sorry, I'm not. If you want, I can hear you. I can reject the cry if you want. I'm not, but if you want that, I'll give them an opportunity to file an affidavit by next week. We'll consider the whole matter, finish it off.
Those are on the legal. I am only on the legal part, Lord. Because this is a civil death of the company, my lord. My bids are not considered. I cannot participate. It's a civil death for me, my lord.
Not
3 of the bids already rejected in last 1 week, my lord. 1 I have already placed on record, my lord.
Mr. Rajiv, you have also, you know how to get those things out of the way. You have orders, taken orders. I think I have passed orders in your favor, Justice. There is orders of my Lord Justice Michael, where you had assailed that second part of the thing.
Yes.
So these are not
Lord,
new things.
Lord, these are blacklisting matters, my lord.
They have given notice.
May I submit one thing, Lord? May I submit one thing?
See,
Lord, this
that's
is-
why I said, just show me one line somewhere in the contract that this notice is required not to be issued to the lead partner, projected, but to the all partners in a JV. Just show me one line.
My submission, any punishment order, if it is passed, it has to be given individually to the JV partner, my lord. Not
Yeah, just show me that law. Or a provision in the contract to that effect. Rather, the provision is that everything will be done by the lead partner.
Lord, it's being done, my lord. Everything
Everything is done.
correspondence is shared with them, my lord. Lord, I was not even aware, my lord. I came to know when it was circulated on WhatsApp, my lord.
So you'd say it's a question of law only. We'll hear.
First submission is, my lord, that there is a no legal so-called notice against me, my lord.
We are taking up for final disposal.
Very well.
Right?
Lordship.
Lord, petitioner was a silent partner of the JV, my lord. And petitioner has intimated to the respondent number 1.
Where is the contract agreement?
Contract in that page 137. For even contract is signed by the lead partner only, for not by me.
Mr.
Please follow.
Raj, you are inviting me to dismiss the petition. Why are you taking that? I make myself open.
But my only difficulty is, my lord, my 100 bids are pending.
As prayed for by the Learned Council for the parties, registry to list this matter again on today is 28, 7. On 3, no, 2, 2/12/2020.
But 2 I am in Impala.
Then when 3, 4, 3, don't take 3, take 4.
Can it be on 5, my lord?
5/12/2020. I don't want to reject your prayer.
My only
But
difficulty,
I find it very difficult to allow.
Lord, I will satisfy, my lord, there are the, Lord.
We'll see.
For orders, item number 35.
Who is appearing for the,
Copy may be given in advance so that I can prepare it.
they are not filing affidavit. I've not asked them. It's a question of law only, you said. It's for hearing. We'll put it as, you want me to put it for final disposal? Or no need?
Let him give the reply that they have served with the my lord, so-called notice.
We'll see. Let them.
Let the affidavit file.
In the meantime, it is open for the respondents to bring on record their stand by way of filing an affidavit. At least such affidavit be filed on or before 4/12/2025 with a copy to the learned counsel for the petitioner. Yes. Yes, madam.
Please, Lordship. Lordship, through this petition, we are challenging the notification dated 5th of March 2018.
Now,
Yeah.
5th of March 2018, to the extent that only it limits it to the persons who have taken the land
Yes,
without
Lordship.
any petition.
Freely donated, yes. Lordship.
Now, why this? Wherever there is an accusation proceeding in the state, we will say that all those persons are also entitled to have jobs of grateful. You have sold off the land, right?
Yes, Lordship.
That's the end of the matter.
No, Lordship, that is an admitted fact that my grandfather was paid an amount of rupees 3 lakhs.
Enough. And that time,
Yes.
3 lakhs is a princely amount.
Yes, Lordship, but it has to be noted that that agreement was done with a condition that as and when any
There
gratefulness
is,
arises.
just show me that agreement.
Agreement, Lordship, it's page 25 of the petition.
This is not an agreement, madam. This is a declaration, self-declaration by you, your grandfather. How can this be where is the department concerned here?
Lordship, the district administration.
Who is
represented
this
by that
ESC
ESC.
two? Who is this? What power does he have? What power does he have to bind down the government? He does not have.
But Lordship, normally land acquisition process are undertaken by the district administration. So
No, show me, madam, where is the deed of sale? That is on record. The sale deed is on record.
yes, Lordship.
Whether there is any condition in that sale deed.
Yes, Lordship, it's there. If I may read, Lordship.
In the sale deed.
In this agreement.
Agreement, when was this agreement executed? 94.
94, Lordship.
And when was the land sold?
94, same.
Show me the sale deed.
Lordship, there is no sale deed. There is
No, I
just this
can't.
agreement.
No. There is something. Yes, there is some document was there.
Yes, Lordship. I have annexed some documents, but that is not with regard to this agreement.
Okay.
Yes, Lordship.
This we are not accepting, madam.
But my lord, this is a valid agreement because it is because of this agreement that the land was acquired by the district administration for the purpose of setting up.
This
a
land was
dispensary.
not acquired for any such purpose.
It is written in the agreement, Lordship.
I'm sorry. That will, anybody will get this. And what is the power? 299, madam, an agreement can be made only by the governor, not by any other authority. You can't bind the government by this. Where is the affidavit of the state? You have filed an affidavit?
Yes, Lordship.
Lordship, I have filed affidavit on behalf of government respondent number 2, 3, and 5.
The
That
land
is-
was sold by him for this dispensary. Okay. Why?
Yeah.
After vacations. After vacations, not destroying your Christmas. As prayed for by the Learned Council for the petitioner, the registry to list those matters again after the ensuing winter vacations on a date to be fixed by. But
Lordship, if I may be allowed to take fresh steps upon respondent number 7 by way of Dusty. Because the notice is still awaited.
the petitioner, in the meanwhile, shall take steps for service of notice upon the respondent number 7 by way of Dusty, routed through the registry of this court. On effecting of such service, the petitioner shall file an affidavit.
Much obliged, Lordship.
What of-
For orders, item number 36.
Yes, where is the Learned Counsel for the petitioner?
Sinti Younger.
None appears for the petitioner on call. Mr. Y.P. Gupta, Learned Counsel for the respondent, railway respondents is present. For the ends of justice, registry to list this matter again after.
Your Lordship, there is only one issue. Since the arbitration proceeding they have started, so any relief under Section 9 of the Arbitration Act.
That's what I was telling the other day. Let's see if he comes.
Yes.
Call after some time. He was here.
Yes, Your Lordship.
Maybe in the other court, let him see.
For hearing, item number 37.
Madam, any instructions on
Yes,
this?
Lordship.
What do they say?
If vacancy arises, Lordship, his case will be considered.
Is there any vacancy expected in the anvil?
There's a vacancy.
There is a vacancy.
Yes. Still a
So you apply in terms of we're not coming in. You apply in terms of para 4 of their affidavit. No.
Yes, yes, yes.
You apply
Yes, my lord, that is
because
the
they have
one of
now,
the-
they have now said in the affidavit that they'll consider your case.
Yes,
Don't put madam to problem. You take that plea, file an application. If they give you, they give you. But this court finds it very difficult to issue a direction here because that may prejudice many. You take steps as prayed for by the Learned Council for the parties, registry to list this matter again after the ensuing winter vacations on a date to be fixed by. In the meantime, you take that paragraph, approach the authority, say this is the vacancy you have undertaken before the court, you will appoint me,
yes.
regularize me.
Well, I'm not, even the, others, the government has forgotten the name of the petitioner for appointment stating that there's a vacancy.
Beautiful. Let it continue. By that time, if it happens, we'll close it.
Yes.
Because if we pass an order, it becomes a law. I'm not very confident with this. Okay.
For orders, item number 36.
Yes, have you examined?
Yes, my lord. I am in full agreement with my lord.
You are Mr. Sun.
Yes, lordship. However, yes, my only request is I may be given protection for
1 week.
My lord.
Senting,
15
1
days
week.
the-
No.
15 days the other day.
That today it became half. But Mr. Santing, Learned Counsel for the petitioner who submits on instructions that he be permitted to withdraw the present writ petition with liberty to approach the appropriate forum under the provisions of the Arbitration Act 1996. 1996?
My lord.
Arbitration Act. Give me a copy of Arbitration.
Act. 1996. Yeah.
1996, praying for grant of interim release pending conclusion of the arbitration proceeding already underway between the parties. First off, prayer is not objected to by Mr. Y.P. Gupta, learned counsel for the petitioner. First off. Just write one line before Y.P. The learned counsel for the petitioner also prays that he be granted 10 days time.
Lordship, 15 days.
15 days time.
My lord.
To approach the competent forum and till such time the interim orders operating in the matter be continued. Full stop. Now, Y.P. Gupta has not objected. In view of the above, the present writ petition stands dismissed on withdrawal with liberty to the petitioner to approach the competent forum under the provisions of the Arbitration and Conciliation Act 1996 for interim reliefs. Also, in the event such proceedings are instituted by the petitioner within 15 days from today, the interim directions passed by this court-wide order dated 18/8/2025 shall continue to operate. However, the said order would not be operating with effect from the 16th day from today.
My lord.
Full stop. This court has extended the interim directions only to facilitate the petitioner to institute proceedings and not to suffer any prejudice in the interregnum. However, such extension of orders would not be binding upon the court, considering the application filed by the petitioner, and such application shall be so considered by it on its own merits.
Deeply obliged, my lord. Oblige, your lordship.
For hearing,
Now, Mr. Gupta will also not go for an appeal.
Yes, sir.
for hearing, item number 38.
Here, indigenous is district-wise.
Yes.
And this matter has to be heard. This matter has to be heard. When?
Worship, we can take up the hearing today.
It will take time because I'm not here. I don't want to. You are for the Kutoli Sekyu, that lady, right? Her indigenous certificate has been cancelled. Just one line.
Lordship, I'm claiming appointment on land ownership basis, and I'm challenging.
Oh, sorry, 37. I was on 38. Oh, sorry, 37. 38.
38.
Okay. Sorry. Okay. Land ownership basis. Okay. And you were appointed on your face value.
No. I'm also a landowner of the Mon district. My lord, I may be allowed to file an additional affidavit because I have just been furnished with the document where there's an agreement, MOU between the government and the landowner of Mon and G, to the extent that appointment to create. Yes.
The petitioner in the present proceeding claims appointment on the basis of being a landowner. First off, the appointment of the private respondent is under challenge in the present proceedings. The learned counsel for the private respondent submits that the private respondent is also a descendant of a landowner.
Yes.
Landowner. Sorry.
Landowner.
In view of the above, he prays that he be allowed to file an additional affidavit. prayer accepted. Petitioner to file the additional affidavit on or before 3/12/2025. Registry to list this matter again on 5/12/2025. There was enough confusion already.
Yeah.
Now you want to add to that. Okay. add.
Confusion.
For hearing item numbers 39 and 40.
This is the matter which has come back. Indigenous. Yes. Who is for the petitioner in item number 39? You are there.
Worship, no, item number, WBC 176, I'm for the petitioner.
No, you are for number that was sent back by the restored by the
Yes, Worship.
division.
Yes, Worship.
Okay. Now your case is that she is not an indigenous.
She's not an indigenous.
She is a Naga.
No, not.
She is not a Naga.
Not that.
Then what is she?
Worship.
Yes, you are not a Naga.
Malan, the mother is a tribal Naga from Somi community, but the father is not a tribal.
So what would be the condition in such? Yes. Now, why should we hear you?
Yes.
What in this condition, what is the position that?
Worship, in such a case, Worship, we come to page number 31 in
Okay,
the
okay.
in the
Just tell me how.
They're not the Naga, the father is not Naga. And he's claiming that his father was slaughtered by the Naga.
That will not happen.
Yes.
So that much only.
Precedent has already been set by division bench on earlier occasion, Lordship. And
no, division bench has not set any precedent. It has remanded back the matter only.
No. Lordship, there is another case already a similarly situated person. Lordship, a similarly situated person has already been granted the status of indigenous inhabitant.
Show me that.
Lordship will find this judgment I have annexed this in my thing.
Lordship, the issue involved in this writ petition, which was disposed of earlier by the appellate court.
Annexure 8, Lordship, page 54.
Affidavit of respondent?
No, Lordship, in my writ petition, number 296.
296.
Yes, I'm the petitioner here in the.
Oh, you are the indigenous thing. Yes. Page.
Page 54, Lordship. Page 54 is the judgment.
Lordship, the judgment is reported in 1998, volume 2, JLD also.
19. Where is that? Just show me that JLT judgment.
So the issue involved in this case is the totally differing ground.
Lordship, the last para is the operative part.
Okay, when was your father adopted? After your mother's marriage or before that?
Earlier, my father, the petitioner's father.
What is the materials available on record to demonstrate that yes, the father after adoption lived like a Naga?
Lordship,
name change. What is it?
Lordship, there is no written material, and therefore inquiry is
Your father is alive?
To be conducted.
Father is alive? Father is alive?
Father is not alive.
What inquiry can be done?
Lordship,
Who had adopted him?
Earlier, the father of the first marriage mother has adopted the petitioner's father. Later on, one person from another another village has adopted my.
How can
my
there be
father.
repeated adoptions? What is the basis?
And-
What is the basis that you are saying that he was adopted, other than an oral statement? And in the inquiry, how was it determined?
Lordship, the village council,
Those people are not there,
those people were not there, but
and he is given a Naganim,
Lordship, later on, Lordship.
but not when he was adopted.
Yes, Lordship. But Lordship, in this same case.
Okay,
in the
we'll
division
consider
bench
this.
Matter.
This has to be, because it has come back from the division bench. Now it has to be, merits have to be assessed. We'll have to go into that. You have a stay order. You have a stay order.
Lordship, yes.
And you are working?
No, Lordship, both of us are not working.
Not working, okay.
Lordship, the only issue is, Lordship, the state government has issued a notification in year 1977. As per this notification, in order to qualify as an indigenous inhabitant of Nakalin, a person has to qualify 3 conditions. During the inquiry, that issue was raised. The petitioner submitted an application before the inquiry that she does not has the requisite documents in order to prove herself as an indigenous inhabitant in view of this 1977 notification. That is an admitted fact.
That's a fact. That's a
in the inquiry.
But in spite of that, the inquiry report went in her favor.
No, inquiry report went against her.
Against her. That's why she put it to challenge here.
She put in the challenge in the petition.
The certificate was cancelled, sorry. And in
Certificate
your-
was also cancelled subsequent to the inquiry.
Then that was stayed by this court.
Yes, Lordship.
Yes, Lordship.
Your case is that in the selection,
I made number 2.
your case was rejected because you participated in the selection and accordingly you were held not to
I may stop.
top. But you did not know about her antecedents so you came back.
Lordship, the village council chairman, although they may not be in the village council of his base at that point, but they were in the position to depose.
Show me the order.
In favor of the.
Show me the order passed by the authorities, which is challenged. She is serial number 1, you are serial number 2.
I'm serial number 2.
So the notification of 77 is at page 7 of your affidavit by 1, 2, and 3.
Lordship.
And where is that order which is under challenge in this present in your case?
Page 74, Lordship, in my writ petition.
Okay.
Lordship, my contention in this writ petition is
So
that.
we come to that. How can this court determine this issue?
Lordship, I'm just praying for direction to be given so that fair inquiry may be conducted.
Okay.
Because my contention.
Okay, we'll uphold this. We'll cancel your selection at serial number 1. We'll allow the petitioner in the other case, being at serial number 2, to be considered for appointment. You proceed before the learned trial court, establish your right, being an indigenous. Because this is a disputed question. We can't go into this.
Lordship, in the inquiry, that they made it. Lordship, they have submitted a representation. Your representation is at page number. Starting from page. In the next representation.
That is it.
Lordship, we come to page number 67.
Of the
Of the writ petition, of the petition number 296.
67.
Lordship. Lordship, we come to para 3. No, but Lordship, para 2 and 3.
2 and 3.
Should Mary. That as per the statement, as per the state government notification number 22, the criteria for qualification of a person of indigenous inhabitant of the state of Nagaland for the purpose of employment, where one criteria which needs to be fulfilled in order to claim the status of indigenous inhabitant is that the name of the person or their parents' names or their legitimate guardians in case of a minor should have been enrolled in the electoral roll published on 15/12/1963. It may be mentioned that the name of the undersigned grandfather, late Shahini, is enlisted in the Buku.
Where is the verification report? Page.
What you will find this verification report in page 90.
90.
90 and next 26.
Page 90?
Page 90, Lord, and 91, Lordship.
No, the report. Where is that report? This is
Page number 71.
Page?
71. No, 77.
This is the order.
If I may, Lordship, at page 78, at serial number 1, Lazami village, from where the petitioner's father hailed.
Give me 2 minutes.
Lordship.
Lordship, if you see the second last line.
2 minutes, Mr. Come to page 80. These are the certificates being issued in your favor. Where is the adoption here?
Page 80, Lord.
80.
80.
Annexure 20.
Annexure 20. Lordship, this person is a stranger to my case, Lordship.
Okay.
And
then come to
out of nowhere, this person was called to the
Mishilimi Village Council.
Lordship. Pardon me, Lordship.
Page 81.
Yes, Lordship. Lordship, all these documents were against me, and I was not given the opportunity to cross-examine the other party, Lordship.
Now you go before the trial court, you will have full opportunity.
Lordship, my only contention is the inquiry was not fair. Just give me another one more chance to conduct a fair inquiry. That is my only prayer, Lordship. And a legal person was allowed to sit on representing the other party, whereas
These are only fact
I've
finding.
written an objection also.
See,
Lordship,
Mr.
but
Counsel,
I was not
Mr. Counsel, you have to
This is
go
not a
before.
fair inquiry, Lordship.
I'm sorry if you have that, because this is all disputed questions now. How can we come to a conclusion? He'll say that those documents, government will say, those documents came on record in an inquiry. And it's not a case that you will have to be cross-examined. These are material collection. They are collecting information only. It's not a cross-exam evidence being collected. No, they are gathering information. And that gathering process, they come, then take a decision that, okay, on the basis of this, not proved.
Lordship, I'm not asking for anything more. My prayer is very limited.
That is something which cannot be given, because if I give that to you, I'll be
Prejudicing.
prejudicing him.
Knowing the inquiry, you have to submit this representation dated.
He said he had no documents, no documents.
27.
I have no documents. I only have
That's
oral
what I
evidence.
said.
When you said no document.
That can be presented before the inquiry.
That is it. You oral evidence, best place to adduce that is the trial court. You have your instructions.
Lordship.
You have your instructions, we'll take it up at 2 if required.
Lordship, if another inquiry is.
Otherwise, I will have to consider this case on merits. It may not be favorable to you.
Lordship, I respectfully submit, even on merits, Lordship, that
as agreed to by the learned counsel for the parties, the registry to list this matter again on Tuesday, 2/12/2024. Young boy, I don't want to, but not convinced. When I'm not convinced, I can't. Simple law is that when there is a disputed question of fact coming before me and I cannot adjudicate on that and conclude that which is correct, this court does not have jurisdiction. That much only I understand. Beyond that, I don't understand. And he is at number 2. If you go, he comes in.
Yes.
But I can provide for that. You can go before the trial court, get your rights, because this will require a determination. This will require a determination.
Lordship, if the matter is heard on the next date also, the same conclusion will come. So the matter may dispose of us.
Lordship, I may be permitted to get further instructions in the
2 o'clock.
2. At 2.
At 2.
Lordship, 1 week time maybe.
No, Tuesday. Tuesday. Will not be suffering. Tuesday.
Lordship, I have another hearing on Tuesday.
We study, we come, you must not be tagged up with one matter. You will have to do 10 matters. That's the age now.
If
1-2 hours more in the night.
There, Lordship.
No, Tuesday. I don't want to cause. Thursday? Okay, Thursday. He is so benevolent. How long have you been in practice?
Lordship, more than 10 years now.
I shouldn't have known this first. I would not have chopped it. Anyway, fine. Yes.
For hearing, item number 41.
Enhancement of compensation. Additional.
Lordship, here the petitioner brave for damage caused to the own land. But here in the petition, nothing is specific.
No, the prayer is something else.
Yes.
Yes, Mr. Counsel.
Yes, my lord, the petitioners, they are aggrieved landowner and there was additional damage.
The land was already acquired?
No. outside
Beyond ROW.
additional damage.
They are outside the ROV.
There was additional damage done to my land, and the petitioners have submitted representation to the government, but no spot verification was done. So at this stage, I have a limited prayer, my lord, only to carry out spot verification, rating the respondent number 8 and 9 to conduct joint spot verification and bring out assessment of the damaged properties. My lord, the petitioners number to 15, they are individual landowner and their land are located under the jurisdiction of Sumukdima A Village. And Sumukdima A Village Council have issued NOC to a provisional court. And petitioners 16 to 56, their land, individual landowners, they are under the Sumukdima Village jurisdiction. And some land falls under the town jurisdiction.
Now, who has filed this? How many petitioners have filed this?
Petitioners, 70 petitioners.
70.
Yeah, 2 to 70 petitioners have authorized.
Yes, what do you say?
Lordship, in the present matter, I have a limited submission because I'm only a felicitator state. But here, whether I'm a felicitator or I have to give the logistic support to the agency. But the thing is, the petitioner went to the honorable court to go in, to inquire into the subject matter of the petitioner case. That is what I have incorporated in my preliminary opposition. And another question is now they are claiming the damage beyond ROW. And now the question is whether the petitioner property actually was damaged caused by the construction of four line or
That
not.
would require an examination.
Yes, Wex.
That you will have to do the examination, verification.
Yes, yes.
Are you ready to that verification?
No, the thing is, it is a petitioner. Because on the basis of the petition, I cannot go and verify or assess the damage. It is a petitioner. Because petitioner is a dominant lead here. He is a master of the case. So whether petitioner number 1 or 2, whoever may be, that what type of damage caused to his property, whether is it a building or whether it is a farm or plantation, it has to be mentioned specifically by the petitioner. It is not mentioned. So now, in simple, the petitioner prayed to the honorable court to inquire into the case of the petitioner.
What inquiry?
Yes.
Got it.
Yes.
Yes, what is the exact nature of the damage to your property?
The damage, it differs according to the individual landowner. Some landowners,
whether it was a
they are
building-
deprived of their access to the paddy field because of the damage.
There is a building standing, derbies fell, building broke. No compensation paid. There is a land, say you have 200 square foot of land, 100 square foot is under the derby. Now you can't use that. Right? What is the nature? Where do I get that? What is the nature of the damage? He's right.
On Terra
It is that road that we were yesterday considering.
Yes, that street.
On Terra 9, page 19, I've mentioned, if I may be allowed to read off.
No, exactly. There are 70 petitioners. What is the damage caused to the 70?
Some are field, some are petty field.
No, which who? You have come before the writ petition, you will have to give the particulars.
Correspondent 54 is a church body. So their church compound is located under a town itself.
I got it. Whether we are concerned with petitioners in that area, you have joined together. But what is you individual have suffered, each individually have suffered different types of damages. What are those different types of damages? Who has suffered what?
Their forest area were damaged. The forest area were damaged and petty field were damaged.
And the prayer of the Learned Council for the petitioner registry to list this matter again after the ensuing winter vacations. Mr. Counsel, if you want, file an additional affidavit bring these particulars, then we'll ask them. We can't pass a roving inquiry. We have a roving inquiry. Right. Yes, Mr. So-and-so.
Respondents 2, 3, 6, and 7.
Appears for, but don't know, right, just names, both the government advocates. One is for NHIDCL, other is for the state of Nagaland. Naam to lulu bis. Yes.
For hearing item number 43.
Yes.
Your Lordship, I would like to.
Any progress?
No, Your Lordship.
Nothing.
My client is not willing to.
Compromise.
Your Lordship, the last citation which was submitted before this honorable court by my learned colleague, it is under appeal before the Supreme Court.
Any stay?
Your Lordship, I have no information, but this is the last order that was to be listed on.
Lordship, but that order is only about
State
settlement
12,
between the parties, so Lordship.
2025.
Oh, that Karbiang, that
Yes,
my Lord Justice
that
Borwa's order.
Yes. that
Armstrong case, my
Armstrong
lord.
said, okay.
That,
It's not that, but the
Yes,
law,
that is only-
Supreme Court decision is there. One thing, ma'am, please have this. One thing. Your marriage is under the Christian rights, right?
Yes.
It's a marriage under the
Your
Christian
Lordship,
rights.
it is under the church on.
Church.
Because we are all Christians.
So it is a marriage under the Christian law.
No,
Now,
we don't have any Christian particular law, but it is only.
wherever there is a pastor standing and a few believers stand,
Yes.
that becomes the church. I think that
Yes,
much
yes, Your Lordship.
you should give me
True,
knowledge.
true, Your Lordship.
That much I know.
Yes, Your Lordship.
You need not have a structure to be a church.
Yes, Your Lordship.
Any place wherein I'll not use the word pastor, priest and the believers
Yes, Your Lordship.
congregate,
Yes,
that assumes the character of a church.
yes.
So your marriage was in a church.
In
So
the
it's a-
church.
So the Divorce Act 1990 would come in, and it
Yes.
can only be in a court.
Yes, Your Lordship.
Now, court has been forget these judgments, forget these High Court judgments. Supreme Court has said that a court would be either the High Court or the District Court.
Normal courts, yes.
Normal court.
Normal.
How can
Yes.
the order? So
We know, yes.
we will interfere with that. She has already gone up before the
Yes.
family court. The alimony, whatever it is, will be decided.
Your Lordship, only one submission I would like to make. That
That
is,
second marriage of
Yes.
yours, we don't know. That will take course.
Your Lordship, I would like to submit on the question of delay and laches with regard to that.
See, we are considering
Your
this
Lordship,
matter
yes.
not under 226.
Yes, but.
We are considering it under 227.
227, yes.
First, show me there is a limitation under 227.
I would like to submit only two citations of the Supreme Court that if there is delay in laches.
Please do.
then
But tell me, where is the limitation under 227?
There is no limitation, Your Lordship, only delay in laches.
So
Delay in laches.
she came up before this court within.
Your Lordship, I will take Your Lordship, I'll take Your Lordship to paragraph 24 of my affidavit, where I have specifically stated how the delay has occurred. Your Lordship.
Delay and latches, yes, we have.
Yes.
Para?
Para 24, Your Lordship. Para 24.
Page?
Page 35, Your Lordship. If I may read, Your Lordship, that the petitioner respectfully states and submits that the manner in which the petitioner has approached this honorable court by filing the present petition is highly questionable. There is deliberate delay and laches on the part of the petitioner in approaching the honorable court. The Tungi Village Council passed an impugned order dated 16/3/2024 in the month of March 2024. The petitioner did not question the validity of the state order for 8 months. And only when she came into information that the respondent was getting married on 5/12/2024, she hurriedly filed the present petition on 16/11/2024, Your Lordship. In the meantime, on 5/12/2024, the marriage of the respondent with his second wife was solemnized in the church. Under such facts and circumstances, any order interfering with the impugned order dated 16/3/2024 would result in grave injustice to the respondent and his innocent second wife, Your Lordship. So, March, the
Mr. Counsel,
order was
I
passed.
understand.
Yes.
But today, if I hold that the order passed by the village council is void ab initio, null and void, without jurisdiction, where is the question of
Now, Your Lordship.
a delay and latches coming in?
Lordship, in
That order
yes.
cannot exist in the eye of law.
Presently, at least in the Armstrong case, the matter is pending before the Honorable Court for consideration. Now, Supreme Court. The first one which my learned friend has submitted. In that case also, the court has at the end that the marriage has irretrievably broken down. So we are not
That opportunity we
entertaining.
gave you.
So
that opportunity, not only me, the earlier judge considering were also given you. I also gave you.
So if at
And
least
now madam says that she is not.
that portion is considered on the issue of
No,
delay
I
and
cannot.
latches. Your
That-
Lordship,
that-
I will submit.
No, delay and latches we'll take care, don't worry.
Yes,
We'll
if that,
consider that.
that aspect is considered, then with regard to since there is no chance of reconciling before this honorable court, it has to be the alimony and maintenance has to
No,
be determined by the
that we will
original
not say.
court.
We will only see whether the petition has been filed. It's hit by the principles of delay and latches.
Yes.
If we find that it is hit by the principles of delay and latches, that is the end of the matter. We'll have to dismiss the petition.
Yes.
If we find that in the facts and circumstances,
Yeah.
that issue is not coming up, the order is null and void. If we go in that line,
Your Lordship.
then we will interfere with that order passed by the family court and leave the matter at that. Rest for you both to take forward. Means you with
Your
the
Lordship.
petitioner and the respondent
Your
to
Lordship.
take forward.
Your Lordship.
That's all.
My only concern is that with regard to the second marriage. So if I may,
See, I'm sorry.
if I may
If
cite the-
egos are
I'll,
crushed in wrong manners, this is the reaction you get.
Your Lordship, I'll take your Lordship to the.
I tried to,
the side. Yes.
that day I told the learned senior counsel who was appearing
Yes,
that you will not agree, I know that.
I know.
Because it's not the money now that is speaking, it's the ego that is speaking. Otherwise, see the conduct of the petitioner. She has also filed an application for divorce. And she was the declaration that the marriage should be annulled on the ground of adultery.
She has done that, but even that petition, divorce petition was filed together with this writ petition, the present writ petition. Only at that, on the same, within 1 or 2 days, the divorce petition was also filed by the petitioner hearing. Not only this writ petition, but the divorce
Okay,
petition.
we'll
So,
consider all this.
Yes.
But the learned counsel, just write down it, his name, the senior counsel's name. Madam, just write in a piece of paper.
And I'll take I'll just put in my citation before your Lordship. Lordship considering, please.
Please do so.
Yes, yes.
Give me just give the citations, he'll take out the copies.
Your Lordship.
You just give the citations
Your
and the relevant paragraph.
Your, I'll do.
Write down the names. HUD, Mr. So-and-so, learned counsel. Madam, your name, assisted by your name,
Miss Lucino. It's in the gospel.
page, Lucino, LHOUSINO. And Mr.
Tongpok Pongener.
You are?
Tongpok Pongener.
You're not there in the cause list.
Your Lordship, it will be there in the Wakalat.
Wakalat,
Yes,
okay.
Your Lordship.
So-and-so, learned counsel for the respondent. And madam, you are appearing for the state.
Yes, 40.
You have nothing to say.
Yes, I have not, yes.
If they break their heads, then only you will get your role. Hearing concluded, judgment reserved. Before Christmas, I'll pause you. Anyway, nice. I could get the perspectives in. It was helpful. Thank you.
Lordship, my only submission is the divorce petition was filed prior to the writ petition. You were saying we filed it together, but it was prior to the writ petition. Lordship.
For hearing item number 45.
It's nothing, only that we have received it. Heard the learning council for the parties at length, registry, learning council for the parties at length. What I do is I keep both these matters for delivery of orders. Don't both, not for CAV. I'll deliver it from Gauhati. For delivery of order, today, date delivery. 8 তারিখে দে, 9 তারিখে দে। ঠিক আছে? 8th and 9th. I'll come online and I'll pass the orders there. Not CAV. But CAV today. Make it CAV. Tutai CAV. Both CAV. If I forget again, it'll be difficult. Done with?
Yes.
Which item? Item? That matter.
Yeah.
Okay, we'll have it after the vacations if required. Or next week.
After the vacation.
Ask him, he might have an urgency.
Yeah.
Okay, we'll come back at 2. And another one is?
Item number 24.
Okay. They'll have to 2. We'll come back at 2.
For admission, item number 2 to 4.
Yes, have you got your instructions? You are Mr.
Lordship, if I may, I have a small prayer.
Please.
Since the petitioner has been serving from 2017.
Hmm.
Lordship, I think the direction we given that to allow the petitioner from service till the matter is closed, Lordship.
That you will have to approach the appropriate court. There is an interim order here. No interim order. That's what, how can I know? When the matter is not maintainable, if there was an interim order, I would have extended it. Heard Mr. So-and-so, learned counsel for the petitioner in the above noted petitions. Also heard Mr.
M. Lokumar.
M. Longkumar, learned. Madam, you are also appearing. M. Longkumar for the respondents number,
State respondents.
for the state respondents, and Miss for respondent number 6 to 16. So the petitioner hearing, the counsel for the petition, learned counsel for the petitioner on instructions submit that he be permitted to withdraw the present writ petition with liberty to approach the competent court of civil jurisdiction for redressal of his grievances. First of all, the said prayer is not objected to by the learned counsel for the respondents. Full stop. Accordingly, the writ petition, the above noted writ petitions stand dismissed on withdrawal, with liberty reserved to the petitioner to institute appropriate proceedings before the competent court of civil jurisdiction, if so advised. Full stop. Full stop.
For admission, item number 13.
Yes.
I have received without any opposition, so looking by mechanical come the 3 days or 2 or 3 days, so that I'll bring my reply on the court, Lordship. And the matter will be taken up, Lordship, because Lordship without repeating scheme completed this is I'll show my part. And Lordship, this is my last chance to present my case before this on the court. I am pretty sure that I will not, my financial strength, Lordship, will not allow me to support the division bed or the Supreme Court.
Okay. Okay. You get a more breathing space. On the prayer of the learned counsel for the parties, registry to list this matter again after the ensuing winter vacations. So the petitioner, in the meanwhile, shall bring on record his rejoinder to file a rejoinder against the affidavit in opposition filed by the respondents. Also, interim order to continue till the next date of listing. What is the interim order helping you? You are going against public interest.
The affairs of the village are being managed also by the ESC.
The village council is to be managed by the villagers, not by a bureaucrat. There is no exigency. You made such a fervent plea, I could say no. I couldn't say no. So, anyway.